friends, and welcome to this study session of Jurisprudence, Interpretation and General Laws. In this video, I'm going to be starting with the secondary sources of Indian law. So, the secondary sources of Indian law are applicable only when the primary sources are not available. Which are your primary sources? First, you have your statutes and legislations. Then you have judicial precedents. I just read that in JP for short. The third one is customs. And the fourth one is personal laws. Now, it is only when these four sources of law do not exist that we will have to follow the secondary sources of Indian law. So, the secondary sources of Indian law is divided into two parts. The first one is justice, equity and good conscience, and the second one is sources of English law. Now, first we'll go on to what is justice, equity and good conscience. This justice, equity and good conscience is essentially what you would follow or what the judges would apply in case the primary sources do not exist. Now, this justice, equity and good conscience can be best explained through an example. So let's move on to an example of the Indian Contract Act. Now, the Indian Contract Act was drafted in the 1800s. Alright. Now, this Indian Contract Act at the time of its drafting did not or could not have thought of something known as e-contracts. E-contracts is what? Electronic contracts. So at that time, if a contract had to be formed, an offer had to be first made by A, and then A would have to send the letter by post or by telegram or some means of communication to B, and then B would have to reply back to A through the same post, and this entire process can even take up to 2 weeks to even 2 months. You never know, and this is just two types of communication. If A has to reply back to B and then B again has to reply back, it takes even longer. But then with the coming in of e-contracts, A can simply send an email to B, which B will probably receive in a matter of few seconds or a matter of few hours in case, his network is not working or something. And B can even reply through the same email, or he can even reply through SMS, any form of instantaneous communication. Now, when a contract is formed by email or this kind of instantaneous communication, I would call it an e-contract. Now, at the time that this law was drafted, it's not possible for them to have thought that, in the near future, in the next 100 years, e-contracts is going to be how contracts are formed in India. So let's assume that a matter has come before the court. Now, the court will have to depend on the primary sources of Indian law. So they will check for any kind of statute. Now, the statute over here is Indian Contract Act. Alright, so you have a primary source of law. But what does it not talk about? It does not talk about e-contract. Okay, fine. So you cannot use this statute as a source of law. Now, the second one you will have to depend on is some kind of a precedent. Now, there is no precedent because before this, no judge has ever taken into consideration the concept of an e-contract. So, if you have to think about it, a precedent will also not be useful over here. Now, the third thing that you can follow is customs. Okay. Even in customs, what are customs? They must be age-old or must be in existence for as long as anyone can remember. E-contract is a fairly new principle. It is nowhere found in customs, and definitely contract does not even come under the ambit of personal laws. So now we can say that we'll have to apply the secondary sources of law. Now, in this secondary sources of law, what the judge will follow is the principles of justice, equity and good conscience. What do you mean by this? Simply that the judge will use his own, will apply his own mind, and he will apply that principle of law which he believes to be just. Now, what if the situation that existed and had come before the court was that A had sent an email to B ordering a quantity of 100 kgs of chocolate. Now, B supplies this 100 kgs of chocolate to A. Now, what must A do? A must pay up the money. Okay. Now, what A doesn't do is he doesn't pay the money to B. So, B has decided to approach a court of law. Correct? Now, in the court of law, B has complained saying that I supplied 100 kgs of chocolate to A upon receiving an email from him, but A has not paid up that amount of money. What is A telling the court? A is telling the court, no, I only sent an email. This is not a recognized type of contract, and therefore I don't have to pay any kind of chocolate. And therefore, I don't have to pay any kind of money for the chocolate that was supplied to me. This is A's argument. But then what happened over here? A and B technically entered into a contract with each other, and as a result of this email only, B had supplied this 100 kgs of chocolate to A. Now what the judge will do is they will apply the principles of justice, equity and good conscience, and then the court will say that, see buddy, regardless of whether electronic contract is recognized or not, you still asked for this order from B, and B supplied this order to you on the basis of the email that you sent to him. Simply because the law does not recognize it, you cannot go ahead and choose not to pay up this money. So what is this over here? The court of law is implementing justice, and it's doing so on the basis of good conscience. This is what you mean by the principles of justice, equity and good conscience. Now let's come to what's given in your textbook. The concept of justice, equity and good conscience was introduced between personal law disputes, wherein the courts were required to apply the personal law of the defendant if the point in issue is not covered by any kind of statute or custom. Now, this was very simple. At that point in time, the Britishers had just come in to become the administrators of our country. And the Britishers had a certain way of living life. They had different customs as compared to Indians. Indians, we follow different cultures, and not just any one culture. We had multiple cultures. And obviously our cultures did not clash. Therefore, when the Britishers came into India to regulate and govern India, there was the concept of personal laws. Because they believed that yes, Muslims also exist in our country, Christians also exist, there are Parsis also, there are Hindus, there are multiple religions, and each one is governed by their own personal laws. So at that time, the understanding was that with regards to personal laws, if any kind of dispute arises, then apply the principles of justice, equity and good conscience and decide the matter that way. Okay, so here they're specifically saying, in the absence of any statutory law or custom or even personal law, they're also including judicial precedents in this, the Indian court should apply the decision of the case of what is known as justice, equity and good conscience. Okay, now ancient Hindu law also they're talking about. In ancient Hindu law itself, we followed these principles of justice, equity and good conscience. But then where we actually started implementing it was that after the time of British administration in India. Now, I know many of you all already know your Indian history, and how did the Britishers come about to start governing our country? They did so by the existence of something known as charters. This charter was a legal document that was given by the Queen to these people to come and implement in our country. So even to set up courts of dispute, or your high courts as we know it, a charter had to be given. So the charter of several high courts established by the British government directed that when the law was silent on a matter. What do you mean by this? That means there was no law governing that particular thing. So nobody knew what to do with it. At that point, they must decide on the basis of justice, equity and good conscience. In this case, they are specifically talking about Hindu law, but the understanding is that in the absence of any rule of law, then the courts have the authority to decide cases on the principles of justice, equity and good conscience. Now, because we were largely governed by the Britishers, a lot of our laws comes from the Britishers. The Britishers, or I will also call them the English administration. Okay, so that's what I would call as English law. So, if we are unable to find the source in our own law, okay, that means we don't have a statute, precedent, custom or personal law, then we'll have to refer to something else. That is, okay, we have justice, equity and good conscience, but what are the other sources that we can refer to? We can refer to English law simply because all our laws are fashioned out of the laws made by the Britishers. Okay, so the English law itself, that is the law made by the Britishers itself, has its sources in common law, law of merchant, principle of equity, and statute law. So let's look at what each one of them are. The first one is common law. So common law is actually a set of principles that are evolved by the judges when they're making decisions on cases. So very simply, I can say that common law relies heavily on judicial precedents. Okay, we don't follow this kind of law in our country. We actually follow a structure wherein we have high dependence, or we have high dependence on statutes and legislation, and the judges can merely interpret the law that is existing in that statute. Whereas common law is basically just a set of principles that gets evolved over time through judicial precedents. So in these common law countries, you can actually say that the judges have more power than the parliamentarians. Okay, so common law principles have been formed through ages past. For as long as anyone can remember, these principles have been built over time. So they're saying that whenever we cannot find a source in law, or we don't have anything to look back to, we can simply refer to this common law. Why? Because common law consists of your immemorial customs over here, your judicial decisions, and even textbooks on jurisprudence. So common law takes in all these three things, combines it, and that's what common law is. So if we are unable to find any source in law, we can even refer to common law. The next one is known as law of merchant. What do you mean by law of merchant? These are all your laws which help you understand what was the laws on the basis of trade. Who is a merchant? A person who is a trader of goods. And what are the laws that are applicable to him? So law of merchant is also known as mercantile law, and there's a lot more in your textbook regarding mercantile law, so let's go to that later. The third one is known as your principle of equity. What do you mean by principle of equity? Remember, even when we were studying about the justice, equity, and good conscience, we understand what justice is and we understand what good conscience is. But what do you understand by the principle of equity? Now, for all you company law students or you account students, equity is not the shares in a company. This is not the equity that they're talking about. Equity is just a body of rules. Okay? And the primary source of which is neither custom nor is it written law. It is neither unwritten law nor is it written law. Okay, so what exactly is it? It is basically those dictates of conscience which have been set forth and developed in the courts of chancery. Who are these people and what is this principle of equity talking about? So first thing they're saying is that equity is a set of rules. Okay, these rules which are neither custom nor written law. That means it's neither unwritten law nor is it written law. What exactly is it? Rather, equity is the command of someone known as the courts of chancery. So who's this courts of chancery? Very simple. Generally, Generally, in the common law principles, the king is considered as the fountainhead of justice. That means if anybody has any dispute or is aggrieved or any problems they have, they will go and file a petition with the king. Now the king will decide on that dispute and he will give his decision. But you see, the king was not the last. What would you call it? The king was not the last person who you could go to for solving the disputes. If someone was not satisfied with the decision of the king, they could always file a mercy petition with the king in council. So who is this king in council? It's someone other than the king. And the king would refer these petitions to his chancellor. And the chancellor was usually the bishop. So who's a bishop? He is a man of the Christian faith, and he is considered to be a well-read and knowledgeable man. So what exactly are they saying over here? Here you have the king, Okay, everybody should go to the king in case someone has disputes. But what if you are unhappy with the decision of the king? You can go to the bishop or the chancellor. The bishop is another name for the bishop is also the chancellor. Now this person, right, he will not follow the laws of the land. In fact, he won't even follow the customs of the land. He will give his decision on the basis of his own common sense or natural dictate. He'll give his decision on the basis of common sense, natural justice, and good conscience. Yes, it's something like justice, equity, and good conscience. It's as simple as that. So, ultimately, what is this principle of equity talking about? It is a body of rules which is not customs nor is it statutes. That is not written law or unwritten law. Rather, they're basically a set of rules which are made by the courts of chancery. Who's the courts of chancery? They're considered a kind of appellate court to the king. Everybody has to go for their disputes to the king, and if the decision given by the king is not satisfactory, then they can apply to the king in council, who is headed by the bishop. Now, this bishop will not follow the customs or the laws of the land. Rather, he will follow his own common sense. He'll apply his own concept of natural justice and good conscience. And therefore, he is known as the equity court. As simple as that. But there are certain rules with regards to equity courts. The two main rules in this equity, while approaching for equity, is that he who seeks equity must do equity, and he who comes to equity must come with clean hands. What do you mean by this? A person who seeks equity, that means he seeks justice by common sense, natural justice, or good conscience, must also do equity. That means he must also adhere to the decision given by this bishop. See, he is coming to the bishop simply because he was not happy with the decision given by the king. Now, after the bishop has given his decision, this person cannot be like, okay, I'm not following this order also, I'm not happy with it, so I will not follow it. No, if you're coming to the bishop, then you must follow whatever the bishop says. Whatever his final judgment is, you have to follow it. And the second rule, that is, he who comes to equity must come with clean hands. So, a person cannot commit murder and then come forward and petition to the bishop. A person who has stolen goods or has committed some crime must not come to the bishop for justice. That is what they're saying is, he who comes to equity must come with clean hands. Clean hands meaning he must not have any criminal record, something like that. Now, the last thing is known as statute law. So, statute law is basically just, like I said, any law that's made by the parliament, which can either be of supreme legislation or subordinate legislation. And they haven't given in much detail over here. So, what I can say is that the sources of English law are common law principle, your common law, law of merchant, which we will study in a bit, principle of equity, and statute law. So statute law is again just those rules which are formed by parliamentarians. Mercantile law has existed far and long before any other laws have existed. It has not existed simply as a law. It could have simply existed as some kind of a custom. Okay, so for as long as we can remember, if person A wants to buy rice, okay, but he has only milk with him, okay, but person B has rice. So what will they do? They'll do a barter exchange. A will give milk to B and B will in return give rice. Now this was known as the barter system. Then after one point they realized, see, the value of milk and the value of rice can be two very different things. Okay, for maybe 10 liters of milk that this person gives, B will only give like half kg of rice, because he believes that's all its value is. Okay, so this system changed and then they finally brought about a kind of a standardized weight system. Okay, where they said that, see, 1 kg is equal to so much and therefore in return you should give so much in exchange or whatever. So what we've understood is that mercantile law has changed and evolved over time. and therefore I can call it one of the most oldest sources of law. So what are the sources of Indian mercantile law? You can take reference to English mercantile law. So that means whatever the English, that is the Britishers, followed as mercantile law, we can refer to that also, because our laws are fashioned out of their own laws. Next one is acts enacted by Indian legislature. So these are your statutes and legislation. Okay. Then judicial precedents. The judges, whatever they interpret on the basis of these statutes, is known as judicial precedents. And finally, customs and trade usages. So starting with English mercantile law, they're saying it's just an adaptation of English mercantile law. But wherever modifications were necessary, it has been incorporated in to provide for the local customs. So therefore, English mercantile law is applicable to the Britishers or the English people. Their customs may have been different from ours, but it could have been modified in such a way so as to suit our local customs, and therefore it is also a source of English mercantile law. The next one is acts enacted by Indian legislature or statute law. So what are the statutes relating to Indian mercantile law is, we have the Indian Contract Act of 1872, we have something known as the Sale of Goods Act of 1930, we have the Indian Partnership Act of 1932, Negotiable Instruments Act of 1881, the Arbitration and Conciliation Act, and the Insurance Act. Now, these are not the only laws in relation to commercial law. You have many laws relating to the commercial nature of laws, but these are some of the most important ones. Indian Contract Act being one of the oldest ones. The Sale of Goods Act relate to what are the rules related to selling of goods? What is the duty of the seller and what is the duty of the buyer? Then additionally, Indian Partnership Act. So one partner may bring in money, another partner may bring in expertise. So what is the rules governing them? How can they form a partnership? How does the partnership work, etc. Negotiable Instruments Act relate to all those instruments which you use for paying up some kind of money. So whether you're paying it in the form of cash, or whether you're paying in the form of check, or some kind of a promissory note, or any kind of instrument which you're saying that, okay, I'll give this to you now, it is worth 5,000 rupees. So the Negotiable Instruments Act governs that. The Arbitration and Conciliation Act is a type of dispute resolution act. Okay, so with regards to dispute resolution, you don't always have to go to the courts of law. You can even get it resolved by some other means known as arbitration and conciliation, which you will be studying about in the later chapter, and the Insurance Act of 1938. Now the next one is judicial decisions. I'm not going to go much into this judicial decisions because it's very clearly understood that judicial decisions are those interpretations in law which a judge gives. Now the judge will give his interpretation on a law which already exists. So if he has to give an interpretation, then he might give an interpretation on the Indian Contract Act, or on the Indian Partnership Act, or on the Insurance Act, something like that. But if there is no law, if there is no custom, if there is no prior judicial precedent, then he can even apply the principles of justice, equity, and good conscience. And finally, you have customs and trade usages. Like I said, most activities relating to mercantile law have been taken from past customs or trade usages. Now, it can be specifically said that for the purpose of selling 1 kg of rice, it must be done so in this manner. Credit period can be given for a period of 2 months, or even 45 days, or even 15 days. There'll be certain practices which were constantly followed across by traders in India. So wherever we don't have access to certain statutes and legislations, we can always use customs and trade usages. So friends, let's do a quick recap on the secondary sources of Indian law. Secondary sources of Indian law are only applicable when there are no primary sources of Indian law. The first one is justice, equity, and good conscience. This is applicable in the sense that when there is no primary source of law, the judges can apply the principles of justice, equity, and good conscience. Then, since our laws are fashioned out of the Britishers' laws, which I will also call as the English law, we can refer to the laws that the laws that were applicable to them. So the first one is common law. Common law is a set of principles which are set up by judges. It is the judges who combine customs or existing trade, existing practices, or even textbooks, or expert opinion. They combine it all together and they form a body of principles. The second one is law of merchant. That is all the laws relating to the trade usages in our country. So a merchant law is one of the oldest sources of law, and we can find its source in statutes and legislations, or even customs and trade usages, as well as judicial precedents. The principle of equity is a set of principles which is neither customs nor is it statutes. That is neither written law nor is it unwritten law. Rather, it is a set of dictates. That means a set of commands given by the courts of chancery. Who's the court of chancery? It is a person who consists of the bishop and certain other people who you can go to in appeal from the king. Because the king, if you are unhappy with the decision of the king, then you could always go up to them and they could disregard all the existing laws that were in place. And they could apply their own concept of justice, equity, and good conscience, or even common sense, essentially. And finally, statute law. So this statute law is basically that if no current law exists, then what was the law that was existing prior to this, if there was any law? These are your secondary sources of Indian law. So friends, I hope you all found this explanation of the sources of law to be interesting and informative. Do leave some comments in the comment section, and don't forget to subscribe and hit that bell icon so that you'll get personalized notifications as I put up more and more videos.